Why Restoration? By Sarah Saliers. 7 Key examples of the lies we've been told, or what fraud against a sovereign nation looks like. 1. The UK Constitution begins with Magna Carta. 2. The Crown has been vested in the person of the monarch since 1066. 3. The resources of Scotland form part of the common assets of the United Kingdom. 4. Scotland became a territory within the new state of the United Kingdom at the Treaty of Union. 5. The UK Parliament has been sovereign since 1689 and remains sovereign across the whole of the UK, so continuing as the English Parliament, with the addition of some Scottish MPs. It is entitled to rule Scotland as though it were now part of England. 6. The UK Supreme Court is the highest legal authority for Scotland. 7. The Treaty of Union was replaced by the Acts of Union ratification, and, as Scotland's Parliament was extinguished, the English Act of Union is now portrayed as the only remaining instrument and falls under Westminster control and discretion. All of the above describe the long-standing position of the UK government and its courts, a false depiction which amounts to, and which justifies, an ongoing fraud against the nation and people of Scotland. The truth about Scotland, a sovereign nation. 1. Scotland entered a treaty-based union in 1707 and brought its own constitutional history into the partnership. It did not inherit English history or the English constitution. There is, therefore, no UK constitution prior to 1707. There is a Scottish constitution and there is an English constitution, neither of which may be lawfully applied to both Scotland and England. The application of English constitutional law and practice to Scotland is a violation of the Treaty of Union and an act of colonisation. 2. The institution of the English Crown from 1066 did not somehow replace the institution of the Scottish Crown at the Treaty of Union. Scotland has a separate and different Crown institution from that in England, resulting in a separate and different character for the Crown estates and for the rights of the Crown in Scotland from that which applies in England. The Scottish Crown represents the community of the realm of Scotland, the people, distinct from monarch, government, and parliament. Therefore, the rights of the Crown in Scotland over the territory and its assets are the rights of the people of Scotland, independent of any government or state. The imposition of English Crown rights in Scotland in place of the Scottish is an act of colonisation. 3. The resources of Scotland are vested in the Scottish Crown, but not the monarch, as in England, and were never available to any Scottish monarch or Parliament to transfer to the control of the Union government. They remain the exclusive property of the people of Scotland. The territorial seizure and control of Scottish assets by the British establishment, conducted under provisions which depend on the character of the English, not Scottish, Crown, is an act of colonisation. 4. Scotland was a nation-state when it entered the Union, with 1,000 years of recorded history, its own languages, cultures, laws, and public institutions, and with its own distinct constitutional tradition, and with its own borders, economy, and international alliances. The negotiations for that new, unified state were conducted by commissioners for Anne, Queen of England, and Queen of Scots, and the terms were ratified by the Parliaments of England and Scotland. The authority of the monarch and the Parliament in Scotland differed from that in England. It was, and remains, granted by the people, the community of the realm. The authority of the Scottish nation, either to enter into, or to withdraw from, a union with England remains, therefore, with the people. The Scottish nation was not extinguished and was not transformed from a nation into a territory when Scotland became part of the United Kingdom. The assertion that Scotland became a mere territory of the United Kingdom by the authority of either a parliament or a monarch, when neither possessed any such authority, is fraudulent and an act of colonisation. 5. The UK Parliament cannot exercise English sovereignty over the people of Scotland, no matter what the Supreme Court rules, when such sovereignty A was never available to any Scottish Parliament or monarch to transfer to the Parliament of the UK, and B is constitutionally unlawful in Scotland. The English principle of political tyranny, that is the sovereignty of Parliament, is specifically excluded from effect in Scotland under the Claim of Right Act 1689. The Claim of Right, ratified under the terms of the Treaty of Union, enacts by statute the sovereignty of the people over their governments, as first recorded in the Declaration of the Clergy of 1310. The imposition of sovereign, English, parliamentary tyranny in Scotland is a violation of the Treaty of Union and an act of colonisation. 6. The Supreme Court cannot lawfully replace the right to remedy under Scots law, not English law, and through the Scottish courts. This right is guaranteed by the still-standing Claim of Right Act 1689. The imposition of the UK Supreme Court, a court which upholds the alien constitution of an English Parliament, as the highest legal remedy for Scotland, contravenes the Claim of Right provisions, violates the Treaty of Union, and is an act of colonisation. 7. The Treaty of Union, which created the Parliament at Westminster, can only be altered by that Parliament where provision for such alteration was made by the treaty. And any alteration must benefit of both nations, and not diminish or remove the rights of the nation of Scotland under the treaty. The reinterpretation or disregard of the terms of the Union, to the detriment of the nation of Scotland, is a violation of the Treaty of Union and an act of colonisation. This colonial kettling containment. 1. The only question at issue for the nation of Scotland is whether to remain within the Union or become independent, because Scotland's rights and interests exist not under the conditions of the treaty or international law, but at the whim and the discretion of the English-dominated Parliament at Westminster. 2. The only remedy for Scotland's poverty, for the destruction of her social and economic infrastructure, the removal and sell-off of her assets to foreign interests, the desperation of her people, and the absence of any public accountability whatsoever, despite the lawful sovereignty of the people, is independence from Westminster. 3. Independence from Westminster will require a referendum or other vote recognised by Westminster. 4. What is lawful, under the terms of the Union, depends on the say-so of Westminster, or of courts, which uphold only the English constitutional tradition. 5. The only route to independence is through a political and legal system controlled by the British establishment, a state whose fraud against the nation of Scotland is represented as legitimate and fair, and which has rewritten and reinterpreted the history of the Union and the terms of the contract between the nations of England and Scotland, so as to preserve absolute and unlawful control over the territory and people of Scotland. This state openly subverts or discounts the principles of decency, justice, honesty, and fairness in order to serve the interests of its own privileged class. And it does so at the expense of the sovereign people of Scotland and of the principles to which it is an international signatory, and of which, as a member of the UN Security Council, it is a custodian. The international rights of our nation and people. Scotland is not a territory within the state of the United Kingdom. Territories do not enter international treaties. Scotland was a nation for 1,000 years before the Treaty of Union and remains a nation to this day. The creation of a new state, through a treaty, between sovereign and independent nations, did not extinguish the nations or the peoples who entered the agreement, just as it did not extinguish their histories, languages, legal and religious institutions. The lawful establishment and integrity of the new state depended and continues to depend on the conditions of the agreement under domestic law, Scots and English, and international law. The merging of the political and economic powers of the monarch and of the parliaments of England and Scotland did not and could not encompass the rights and powers which are and remain vested in the people of Scotland. Salvo affirms that any treaty accomplished by a monarch and a parliament in Scotland was and remains subject to the limits and extent of the authority of that monarch and that parliament. The limits of such authority in Scotland, including the limits of territorial control, also, and necessarily, define the limits of the UK government in Scotland. The overreach by the UK government of the clear limits of its authority and control in Scotland, fraudulently justified and legitimised under a pre-Union English constitutional tradition, is a crime against the partner nation of the Union and of the terms of the Agreement of 1707, and is an ongoing act of colonisation. Salvo calls for the immediate cessation of this ongoing crime and restitution for the wrongs committed against the nation of Scotland. Such restitution shall be separate from any discussion of or negotiation for Scottish independence, and shall include the restoration of the sovereignty of the people over their governments, representatives, and public institutions, through modern and accessible mechanisms such as the equivalent of the Swiss Constitution ante. Provisions for referendums on demand, and full and free public access to information on all matters of public policy or issues affecting the common good. The restoration of public control, by and for the Scottish people, of the assets which belong exclusively to the sovereign, territorial nation of Scotland, under the Constitution of the Scottish Crown, as representative of the community of the realm. The restoration of Scottish laws, especially those guaranteeing the rights, liberties, and protections afforded to the people. The restoration of the authority of the Court of Session in Scotland, and of the provisions which permit the people of Scotland to instruct that court to strike down any law or statute which does not serve this nation, or which violates the rights of the people. The full and unreserved acknowledgement by the UK government that it has abused the terms of the Union, violated its agreement with the nation of Scotland, exploited its superior numbers within the UK Parliament, and broke in both Scots and international law. In an ongoing act of colonisation, it has replaced the history, constitution, laws, rights, and privileges of the people of Scotland with those of England, a foreign power whose domination Scotland rejected for hundreds of years, and whose political and legal tyranny remains alien and unacceptable to the people of this nation. Salvo asserts that the identity and the rights of the nation of Scotland demand restoration, that the wrongs committed against this nation demand restitution, and that the confidence, self-respect, social justice, and political freedoms, which Scotland urgently lacks today, depend on the righting of these wrongs, and the return of all that allows Scotland to call itself Scotland, and not a mere territory of the British state, a poor, sadder, northern version of England.